Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I'm your co-host, Thomas Vick, joined by the other co-host, Seth Wilson. Seth, how's it going today?
Thomas, I'm doing great. We were talking offline here a few seconds ago. I've got a few allergies, so if my voice sounds a little stranger than normal, then hopefully that's the explanation. But feel great and enjoying the beautiful spring weather as we roll here into May. Hard to believe we're through April showers, and hopefully we're going to see some of those May flowers.
Yeah, absolutely. It's been a crazy fast year. It seems like every client that I talk to is saying, I can't believe it's already the end of April or the beginning of May. It's just been a wild and crazy, beginning of the year here, and we're almost halfway through it. So time moves quickly.
Yeah. Well, I have to say, I like the new view. You have got, some of your educational pursuits behind you, it looks like, in terms of some law books and maybe some Indianapolis Colts memorabilia back there. So that's a nice look. I like it.
That's right. I got the Peyton Manning signed football right there, and have all my books from law school. So we did a little bit of rearranging this weekend. I've been in this office for about 9 years, and we just needed to mix it up a little bit. So did a little bit of rearranging, got a new office chair in here, and got a new setup for the podcast. It's not a completely finished setup yet, but I think it's a little bit of an improvement from the blank wall behind me.
Well, we were talking about that. I don't know, last weekend or something, where we're mentioning kind of the growth of those individuals who are doing podcasts, and you watch over time as they figure more things out with how the technology works, or what the lighting looks like, or how the sound is. And it's fun to watch that change over time. And so we always want to produce and give the best content we can to educate folks about the various issues that you will face in an estate planning context. And we also like to, get better in our presentation of that as time goes on. So it's always fun to see changes in that direction.
Yeah, some of my family told me, we can't tell if you're in your office or in a prison cell. Maybe it looks like I'm in an office now. So
Hey, well, now that you're out of, never mind. We won't even go down that speculation, right? That's how rumors get started. We can confirm Thomas is not in prison. That's a good thing. That's a different podcast. You're right.
Okay, let's turn a little bit.
Well, speaking of podcasts, I suppose we should talk about something in the estate planning realm, since that's kind of why the Lifetime Legacy Lawyers podcast exists. But it's always good to have a little bit of fun with life as well. And one of the topics that I see and questions we get quite a bit is, why do I need a will? And one of I think the best ways to understand why the wills are so important as a foundational part of your estate plan was addressed in your blog topic, so it was very timely as well. But also because if you don't have a will, then you are subject to your state, and our context is Indiana, but you're subject to the state rules for how assets will transition on someone's passing. And so that's generally called intestate succession. And in Indiana, there's a statute that sets out the general rules of descent. And so I thought it might be good for you and I to kind of talk through what that looks like a little bit, kind of setting the stage for why a will is so important. Because in my opinion, I don't think the general rules of descent actually kind of carry out what most people intend to have happen with their estate plans.
Yeah, and we don't often do this, but maybe it would be good for us to actually read the rule today and kind of preface it by saying the one that is usually the most affected by the intestate succession statute is the surviving spouse. What happens with the surviving spouse, and what implications are there if there is a will versus without a will? And I think that is one thing that is emphasized the most in kind of thinking about this topic. Generally speaking, the surviving spouse is the one player that is affected the most, in my opinion. So I think I'll go ahead and read the statute, and then we can kind of go through it if you'd like to. So the statute says, except as otherwise provided, the surviving spouse shall receive the following share: 1/2 of the net estate if the intestate is survived by at least one child or by the issue of at least one deceased child; 3/4 of the net estate if there is no surviving issue, but the intestate is survived by one or both of the intestate's parents; and all of the net estate if there is no surviving issue or parent. So there are a lot of contingencies there for just a spouse that this is the first marriage, and you got various people that are surviving the decedent. So I read the statute. Let's make comments on it. Seth?
Well, I'm sorry to put you through that, and I'm sorry to whoever may be watching this, because they've quickly turned away when they're like, "Wait a minute, you're reading me a statute? I didn't want to go to law school in the first place."
Right.
But maybe that piqued their interest as, "Hey, this is interesting. So this is what law is." Yeah. Mm-hmm. So and really, I think that's the key as you're thinking about this. Is there's so many different variables based on who is still living at the time of your passing. And so one of the ways I like to think about this is the question is always going to determine or depend on who your closest living relatives are when you pass. And there's really hardly any way to know that. So when you think about the unknown and being subject to that unknown, having an intestate succession governing document, if you will, by just having no will at all, ends up giving you multiple variables and multiple contingencies on those variables based on if you are a first or subsequent spouse, if there were kids or no kids, if parents are still alive or not alive. How does that work? And so really, in summary, I think what we look at from just that small section of the Indiana Code is that if you are kind of in a normal situation where a spouse passes and there's kids, the funds don't all go to the spouse. And that's really the interesting thing to me, because that's typically what we would want to have happen is, let's take care of my surviving spouse. Then when that individual passes, then we take care of the kids. But that's not how it's set up. And so that can have really interesting implications for you if you don't have that plan in place, especially when it's talking about real estate, for example, or bank accounts and those kind of things. All of a sudden you're a co-owner with your children. That may not have been the intent.
Yeah. And then that leads into, well, how do you deal with an inheritance for minor kids? And is there going to have to be a guardianship that's set up? Are you going to have your surviving spouse, who's also the parent of these children who survive you, go to court and get guardianship of the estate of each one of your children, because somebody needs to have legal authority to act on their behalf, and just being a parent isn't enough. So, I mean, that's just what you're leaving up to chance if you don't have a will. And, that's sort of a lesser discussed implication of, I would say, young married couples who just had a child. They may think, I just need a will because I need a guardian named, but really you need a will so that everything can go to the spouse, as it typically is done. And then from there, if the spouse doesn't survive you, then it goes to the kids. But you can really get your surviving spouse into some legal conundrums and a lot of legal difficulties without a will, because of everything that has to be done, not only for her benefit, but for the benefit of the minor children that were left behind.
Yeah, and it's interesting too, because sometimes there's a financial issue in trying to get a will in place and thinking, I really can't afford this right now, or I know I need it, but really what happens is if you don't put that plan in place, you end up probably costing the estate quite a bit more in the long run, because if you do need a guardianship, now you have a secondary probate proceeding essentially for the benefit of the guardians, and establishing that guardianship over the minor kids and the funds and the different things that are going to be there. You've got a probate issue because you now need an estate to administer the intestate succession statutes and make sure title gets transferred the way it needs to and that type of thing. So it really can end up costing more in the long run than just having that will in place to take care of all of these variables. Plus, now with the will, you will get to set out that which you would actually anticipate and intend to happen without leaving your beneficiaries in kind of that conundrum, as you mentioned.
Yeah. Another legal challenge that can come up if you don't have a will. Let's say there are no surviving children, but you're married and your parents are surviving. Well, then that's a similar problem. It's just going, instead of down the chain, it's going up the chain, so to speak, because the spouse gets a portion when you pass away, but then also your parents get a portion when you pass away. And I've seen it in my practice where, a husband passes away and then the wife survives, but no kids, but parents are alive. And so, going to a nursing home, the parent doesn't want funds from, the son that recently passed away. But, now there's a problem with maybe funds being in the hands of the parent who is in a nursing home now. And that becomes a Medicaid problem, perhaps. So all kinds of things can happen when you don't have a will. You're just leaving things up to chance. And, the one thing about estate planning is that we try to control the controllables. And, we can't plan for everything, but we can plan for some things. And we can plan for, the order of succession of who is to receive your property upon your passing, and make sure that it's directed in accordance with your wishes and kind of subject to your conditions too. So definitely a lot of different contingencies that could happen.
Yeah, and just to reiterate that point, like the law of unintended consequences is kind of a thing in estate planning, right? So if, for example, you pass and all the funds that you would have, be that major or minor in amount, that could disqualify the parent from the benefits that they're receiving, which could then further challenge, because maybe you were the one taking care of them and now they have no other caretaker. And so it just highlights the importance of having that plan in place and not letting the default rules catch things for you, so that you can have that peace of mind. I mean, really, that's what we're talking about.
Yeah, absolutely. And thinking about the Medicaid planning aspect of having a will, you can have built within a will provisions that provide for a special needs trust to be established for any beneficiary under the will. And so let's say you actually do want your parent to receive something and your parent is in the nursing home. Well, you could put a special needs trust into place within your will, and through that you can protect that asset and maintain government benefits for your loved one, whether that's a parent or a child or what have you. So lots can be accomplished when it comes to just doing a basic will.
Yeah, and I think it's interesting too, because you sort of have then that next logical step, which is, well, can I just download one from the internet and put it together? And you can't, right? That there are services available, and you'll see those commercials from time to time that will say, "Hey, just go here, enter your information, and we'll get things put together for you." And a lot of times, the actual documents themselves are not the problem. The issue with that becomes, is it properly signed? Is it properly witnessed? Is it actually effective by the terms? And so I think in my practice, anytime I've seen that type of online created document, or, hey, I just copied and pasted from some forms that I found on the internet, how does this look? I kind of go, well, I've got to go through that with even more of a detailed look to ensure that the provisions that you pulled in weren't from another state that may not apply in Indiana. And so a lot of times it's actually more efficient for me to just draft it from the front end, because I know what my standard language and clause would look like for your scenario. And so that's kind of the balance. And I can't tell you how many times I've seen somebody's documents that they brought to me that were just almost there, but had almost, but had something happen to them, they would have not had the outcome that they wanted. And so I think that was a great point in your blog digest post that highlights that really important thing. And I kind of joke with my clients that when we sign the documents, like, hey, we went to law school, we do all this studying, we practice for years and years to hand you papers to sign your name on. Obviously, our role is what goes in between the front of the document and the signature line. But really, that most important part is the signatures and making sure they're done correctly and are now binding on those documents to make them legal and valid.
Yeah, getting you to the finish line for sure. And one of the, I guess, impediments of doing an online will or an online trust is the client often doesn't know what he or she doesn't know. You know, it may be that the, will for a certain person is just fine, but maybe they're not thinking about that prenuptial agreement that they signed right before they got married and whether that will is going to be in accordance with that prenuptial agreement. Or maybe they have a spouse that is not a U.S. citizen. How is that going to impact their estate planning? Or maybe they've got, a child that they don't really want to have a lot of an inheritance right off the bat because he or she will just waste it or use it on illegal substances or what have you. And so while you're providing for that in a basic will, maybe online, you don't have the provisions in there that you need. I'm just kind of thinking off the top of my head of some things that may not be considered. Well, do you need an estate planning attorney? We talk about these issues every single day. We have people that, pass away and we're talking with the family about what has to happen next. What are the next steps? And, we can kind of see what the future holds based upon our past experience. And, that's on top of the legal research that we've done and our knowledge of the law. But those are reasons why you want to talk to an experienced estate planning attorney. You don't get the benefit of that. I'm sure that on a lot of these online programs, attorneys drafted these documents, but they don't know you and they don't know your specific situation, and so you're at a disadvantage because you really can't replace that human connection that an attorney has when you're sitting right across the table from them.
Yeah, it always reminds me of, I was mowing my yard a couple weeks ago, and my neighbor has someone come in and mow their yard. And our yards are about similar size, but I'm out mowing my yard and trimming and doing all of this. The company that does the lawn service professionally shows up, 20 minutes later they're gone, and I'm not even halfway through my yard yet. and you're kind of going, wow, that's sort of what that looks like. The folks who are experts in that lawn care service can do so much more efficiently, professionally. They have the right tools, they have all the knowledge and experience, and they can come in, finish the job well, and it looks great, and move on. And I'm still at step one. And that's a lot of times that just finding those folks that are available, a good fit for you. If that person across the table from you is a good fit, you feel that they're going to take care of your concerns, take time to listen to your needs and adjust and draft that plan that works well for you. So it's always kind of a stark reminder to me, like I can do what I can do, and this is the experience I can bring to the world, so to speak. But you have a much different experience that you can bring in, and a skill set and a tool set that you can bring to bear. And so sometimes it's better to hire somebody else out to do that because that's what they do.
And it is truly meaningful to you and to me to be able to be in that position to talk with clients about their lives and what the future holds for their family. it really is an honor and a privilege to be able to have those discussions and to take on that responsibility. And I guess I'm getting close to a medium aged lawyer. I'm not sure about that. But I remember early on in my practice, I had a couple clients that told me, we want you to do the estate plan because you're young and you'll be around. And, I think I'm still young and I'll be around for a while longer. But, it's the trust that family placed in me to be able to, be around for circumstances that arise from time to time. So, yeah. Do you need an estate planning attorney? Yes, to accomplish your wishes. But, we value that and we really appreciate clients that come to us and the trust they put in us.
Oh, absolutely. And like you mentioned, I mean, it's the whole sort of namesake of the podcast, right? We're really working hard to become a lifetime legacy lawyer. We want to be a part of the family discussions. We're not going to show up for Thanksgiving dinner most of the time, but we want to be there as, hey, we're a resource to help navigate this area of the law. I can't help you in all areas, but I can certainly help you here. And the trust that requires is something that we take very seriously, and we're very grateful for those clients putting their trust in our firm so we can help their family.
Yeah, absolutely. We may not show up for Thanksgiving dinner, but if you need us to, we might show up at your doorstep and help you sign something that needs to be signed. So
that's right. We did one yesterday in the parking lot because just life challenges for folks, and so said, man, don't get out of the car. We'll meet you right out there.
Yeah. There wasn't an Elvis impersonator there like that one time you told me there was an impersonator.
That was truly the most entertaining signing we've been a part of, was at the Elvis concert. So that was a lot of fun.
Man, life experiences. There you go.
It's amazing. It really is. It really is. Well, Thomas, it really appreciate that discussion because it's a question I see a lot in my practice. And I think one additional point I would add to the online discussion is there's so many different terms and terminology, and terms are constantly, I say constantly, but seemingly always changing. And so you may be expecting a certain phrase or word, such as a personal representative or an executor or an administrator, but the forms that you're looking at have a different term for that. Or you may have a understanding of what a living will is versus a last will. And I can't tell you how many times those terms just cause confusion for people, thinking that they may have something in place, but they really don't. Or they may have just mistermed it, and the lawyer may misunderstand what they're asking. And so really to be able to walk through that process and explain each of the documents so that everyone gets to that point of peace of mind through that plan, again, is what we're trying to get to. And those terminology pieces can be really confusing from time to time.
Oh yeah. And that's one question that I ask clients is, do you have any questions? Did you have a chance to read through the documents? Did you have any questions on that? And I'll hit the highlights with them. I may not explain every single term, but I can make sure that they understand the broad plan that we're putting together for them. And sometimes they get down to the granular level of, what does this particular term, special needs trust, what does that mean? Maybe there's a code citation in that special needs trust provision. And, happy to have that conversation. You're not going to have that kind of conversation with an online will or trust. So,
I always thought when I got to law school, I'd get away from algebra, mixing letters and numbers and all that. All the code citations are a mix of letters and numbers and section symbols. And it's just, it's a little bit like alphabet soup.
With math problems built in sometimes.
Thank goodness for Microsoft Excel. That's all I can say.
That's right. Well, that does it for another episode of the Lifetime Legacy Lawyer podcast. Seth, what's the best way to get in touch with you?
We are located here in the heart of Hamilton County, Indiana, up here in Noblesville, and that's our web address, noblesvilleattorney.com. How about yourself?
The best way to get in touch with me is go to the website vicklaw.org and book a call. vicklaw.org and book a call. Well, we'll talk to everybody next time. Seth, I appreciate it as always.
Thanks so much, Thomas.